Hello everyone, this is Christina and welcome to my week 9 presentation on the issue of felony murder in the Elkhart 4. I'm sorry that I cannot do this video in present mode. If I did that, then I wouldn't be able to record my screen. I'm not sure why it does that, but I apologize for the lack of an aesthetically pleasing video, but hopefully it'll be okay. So let's jump into question 1. Question 1. In your opinion, was this a proper use of the felony murder charging power the prosecutor has? I said, no, I don't believe that this was a proper use of the felony murder charging power that the prosecutor has, and my personal opinion on the matter aligns more with Judge May's concurring opinion found on page 14 of the appellate decision PDF that's on our content page on week 9 on eCourseware. So I have in here from page 15, Judge May says, I note initially that the language of the felony murder statute suggests the legislator did not intend it to be applied to a situation like that before us, where the killing was committed by one resisting the felony and not by any defendant. So this resisting the felony just means that the defendant obviously was not the one who actually committed the act of killing the victim. Which I think is definitely important. I'll get into it later. So question 1 continued. So what is the Indiana felony murder statute? That's really important for us to know. The statute may be read as follows. A person who kills another human being while committing or attempting to commit burglary commits murder, a felony. And of course, this is slimmed down to make it a little more applicable to the issue before us and cuts out the other things in the Indiana Code. And then again, this is on page 15 of the opinion. I have it linked here. It's just on a page on justia.com. So you can click on that. I will hopefully be able to attach a version of this PowerPoint to my discussion post. You'll be able to click on that there if you want to read the whole thing. But like I said, I agree with Judge May that while it is understandable why the trial court came to the verdict or decision that they did, the court should shift its stance for how they apply the felony murder rule, especially for juvenile offenders. So that is my response to, was this a proper use of the felony murder rule? And again, I'm saying no because we are dealing with juveniles, which I will also get into in a minute. And just the general circumstances of this case, I don't think that it was applied correctly. Okay, so question 2, what arguments would you use in this case for and against the felony murder rule? So for, I would say it holds offenders accountable for the death of another person who that offender put in harm's way due to their unlawful and dangerous actions, which are the original, I guess you could say, like, cause of using the felony murder rule in like being applicable to the case. So that does make sense. And then the foreseeability aspect of the felony murder rule could then also potentially make somebody think twice about committing the original unlawful actions that could result in a killing. So maybe for some offenders, they would think twice about doing it if they knew that there was a possibility that they could be held accountable for somebody dying, even if they themselves did not like pull the trigger or do the action or commit the action that ended up with somebody losing their life. So kind of just, yeah, so that, and then also the overall nature of the felony murder rule could act as something that makes a potential offender, again, think twice about committing the crime at all. So like just thinking twice about even committing a burglary at all, you just never know what could go wrong, type thing. So especially something that's violent, where somebody could get dangerously hurt or killed. So kind of more in the realm of the foreseeability aspect could prevent a potential offender from committing the original offense. But then against, the felony murder rule can result in someone being held accountable for a killing that they never even intended to happen or foresaw happening, as is the case before us today. Judge May also brought up a great point about the felony murder rule and its application to juveniles who cannot be considered the same as adults when it comes to the ability to foresee events happening, especially with the murder in question. I think it's a serious flaw in the felony murder rule logic. And also, intent is not considered whatsoever when it comes to the technicalities of the felony murder rule. The court need only prove that they were intending to commit the original crime that kind of gave cause to the killing that took place. So I do also think that that is a flaw in the felony murder rule as well. Okay, moving on to question 3. What factors would you personally use to determine when the felony murder charge should be applied? So kind of just some questions I would ask. Was the defendant the one who pulled the trigger, or in general just committed the act that directly resulted in the killing, and then that resulted in the victim's death? I think that's a really important thing. I know technically it's not necessary to prove, because obviously in the case before us, the defendant was not the one who actually pulled the trigger. But I think that if it was me, I would ask this question. I think it's a really important one. Also, was the victim a co-perpetrator or not? Justice Sullivan, in citing Palmer versus State, brings up this point in relation to the application of the felony murder rule. This is found on page 15 of the opinion on eCourseware. And I think this is also important. And then also, in consideration of all the facts and context clues that are available, was it reasonably foreseeable that the defendant's actions would result in the killing of another person? So again, coming back to was it foreseeable by reasonable standards that the defendant's actions would result in the killing, even when the defendant is not the one actually pulling the trigger or actually killing somebody? So I think that's really important. And I personally would use those to determine when it should be applied. Okay, question 4. Do you think the jury's verdict was correct in light of the facts and laws you discovered in your research? I believe that the jury's verdict was correct. In fact, in light of the facts and law in Indiana, it says in Exum versus State, page 7 of our opinion, the state need not prove intent to kill, only the intent to commit the underlying felony. So obviously I kind of said this earlier, but I definitely don't necessarily agree with this, but facts are facts and the law is the law. And I mean, technically, according to the law, the jury's verdict was correct. There was undeniably intent to commit the underlying felony, which was the burglary that took place in the Elkhart case. But then also I do disagree on the sentencing, just like the Court of Appeals also disagreed. And then what would your closing argument address if you were representing, one of the defendants in this case in order to obtain a not guilty verdict on the felony murder charge? And I said, again, my personal opinion aligns heavily with Judge May's concurring opinion in the appellate decision. I would say my client was not the person who actually killed anyone. No, I meant to say, nor could he be characterized as an accomplice to the person who did kill the victim. He was merely trying to help the victim escape. My client is a juvenile and as a result did not have the same mental capacity to assess the foreseeability of the felony murder and should therefore not be held to the same standard as an adult. I think that's an overarching thing that should be considered. Just in general. And also, even though intent is typically not considered in felony murder cases, like we just talked about, my client had absolutely no intent whatsoever to do anything that would result in the killing of the victim. It goes against logic, as the victim was a co-perpetrator to the burglary and likely had a close tie or relationship with my client. I think that that's important. And also, in this Elkhart case in particular, the defendants did not even think that anybody was home. So again, there was no foreseeability that there would be a situation that could arise where somebody would get seriously injured or killed or anything like that. So it is not necessarily foreseeable that any of them, especially when they thought that nobody was even home, obviously thought it would be a quick one and done type of situation, and it obviously was not. So I think that all of those factors are important, and I would use all of them in order to obtain a not guilty verdict on the felony murder charge. So that's all I have. I know this was a little bit long, but I felt the need to elaborate on a few things. So thank you so much for listening. Thank you.